now. We are going to call case CR 22-211623, State versus Chad Guy Daybell. Mr. Daybell's here, present, represented by John Pryor. We've got motions scheduled to be heard this morning. The first motion that is scheduled is a renewed motion to sever. The motion's entitled Renewed Motion to Sever from Death Notice Co-Defendant in order to enforce Mr. Daybell's constitutional rights. The motion was filed on January 13th, and the court has considered the motion. Subsequent to filing that motion, the state filed a response entitled Objection to Defendant's Renewed Motion for Severance and Motion to Deny Without Hearing. So there was a request that this matter not be heard today based on the court's prior rulings. The court considered that request, and without need for argument, I'm going to deny the request that I not have a hearing on the motion. So it is scheduled for hearing today, and I will allow argument to be presented. However, of course, I'll consider any objective or objection argument proffered by the state. Who's going to be arguing this motion today for the state?
I will be, Your Honor. Thank you.
Okay, thank you, Ms. Blake. So, Mr. Pryor, then, your motion to sever, if you'd like to present argument at this time, you may.
And Judge, may I have permission to remain seated?
Yes.
Thank you, Your Honor. Judge, the motion for severance is based on what had previously been argued, and to some extent the state is correct. I did fashion this in a renewed motion to sever. But also in part, Judge, it was based on the last hearing in which I was here on a motion to continue, and this court had identified. And Judge, I'm not going to put words in your mouth or how you phrased it, and if I phrase it or the state feels I did, by all means I'm welcome for the correction. But the gist of it, Judge, was simply this, is that you were conducting a balancing test between Ms. Vallow Daybell's right to a speedy trial against Mr. Daybell's right to be able to provide a sufficient defense based on the evidence that is still unavailable to the defense. And the court had referenced the fact that there was no motion to sever. I had anticipated that before I came to trial or for the last hearing, and just before that time, Judge, I filed the motion to sever just so that if the issue came up, I'd be able to tell the court, yes, I contemplated that, quite frankly, the court needs to consider whether there needs to be a severance or not. My concern is this, Judge, is that given the state of affairs, we have a discovery problem, and the court touched on that a little bit about the DNA evidence. I would report to the court, without disclosing specifics, that the prosecutor and I have agreed that at least the DNA evidence could be submitted to another institution to be tested, and that's going to take at least 3 weeks, maybe more.
Your Honor, the state is going to object at this point to hearing this, and this was part of why we'd requested that it be denied without hearing. The renewed motion to sever, the briefing contained in it, has no information that's being provided today. The state was not adequately put on notice that this was the basis for the motion to sever. In addition, Mr. Pryor's filed a motion to dismiss that he's properly noticed up for hearing at a later date that essentially is covering the same information that he's starting to get into today. So we would request, again, that the court deny the motion to sever based on the filing, and that if Mr. Pryor is going to be arguing a motion to sever for other reasons, that he properly put the state on notice with regard to that. I think the state was accommodating last time that we were here on the motion to continue, where information was presented that was not in the filing, and in order for the state to properly respond and confer with the right witnesses and the right documents, especially with regard to discovery, the state doesn't always have all that information off the top of our heads, but if we're allowed to look at our records and confer with the appropriate witnesses, we can properly present argument and the representations to the court. So we would request that the court simply maybe not even deny this, but just continue it out if it's going to be argued on a basis different than what was in the renewed motion to sever.
And Judge, in response, what I would say is that the court put the prosecuting attorney on notice last time when the court, on a motion to continue, actually conducted the analysis that was necessary. I will afford the state, if they want additional time, Judge, I'd be glad to continue the severance motion till the 23rd if they're willing to waive the necessary time because the 14 days is today. So if they're allowing me to have that motion to sever heard on the 23rd, I'd be glad to accommodate that with the understanding, Judge, that I'll file an amended motion that includes all of the discovery issues, the significant discovery issues that I've encountered, as well as the other things that have been filed, not only ex parte, Judge, but under seal and other matters, and incorporate all of those arguments that apply in this case to support my motion to sever. So I'll be glad to stipulate to the 23rd if the state is agreeable at this point to allow me by week's end to file an amended motion, or I prefer Monday to file an amended motion to address all of the other issues that can be included in the motion to sever to support that motion. I'll be happy to do that, Judge.
Okay. I've considered the arguments there. The court has to consider a couple of things. First, judicial efficiency and economy in using the time we've got set aside for hearings. Second, the proximity of the approaching trial, which is of a concern. It appears to me that under any circumstance, the issue is probably needs more time to flesh out in terms of the relation to the discovery issues that I did mention the last time. So while I would permit argument on it today, if the parties believe that the matter can be more fully argued with additional answers to that evidentiary question and allowing the state time to respond. There's been a suggestion to set this to the 23rd when we have more motions scheduled, and I'm fine to do that. In terms of the timing for that, it would require shortened time frames for filing and response, because that's 2 weeks from today. Ms. Blake, does the state have any issue with shortened time frames for filings and response? And we could set out a schedule for those time frames today if we move the hearing to the 23rd.
No, Your Honor, I think that is an appropriate suggestion, and I think in light of the court's comments with regard to judicial efficiency and economy, I think that would actually be beneficial as well, because I believe we could start argument today potentially, but we'd just be carrying it over to the 23rd or most likely have another hearing related to this. And I think the motion to dismiss is related to a lot of these arguments as well that appear to be Mr. Pryor is kind of starting to get into. So I think having those heard in conjunction would be appropriate.
Based on that, then, we'll continue a hearing on the motion to sever. I'll allow additional filings from both parties here. Mr. Pryor, you've indicated you think you might need till Monday the 13th. Is that adequate time for you to sever?
It should be, Judge.
Okay. I'll require you to file any supplemental filings that relate to your motion to sever by the end of, well, no later. We can file at any time now with the filing system, so they need to be filed sometime on the 13th. And then if the state's going to file a response, there's a judicial holiday on Monday the 20th, so there's going to be a whole lot of advance notice, but I'm thinking maybe the 21st. It's either the 17th or the 21st for the state's response. 21st going to be acceptable.
Judge, can I have till the 22nd to file a reply then, if to the state's response?
Yeah, that Monday holiday kind of.
Your Honor, the state we wouldn't have an objection to that because we recognize Mr. Pryor would be getting our response pretty close to the time of the hearing. So if he needed to file a reply, I think that would be appropriate for him to have till the 22nd to do that.
Okay, that's fine. We can do that then. And any reply just by the 22nd. So, Mr. Pryor, your supplement February 13th. The state's response is due February 21st, Tuesday, and then any reply briefing Wednesday the 22nd. Hearing will be held on the 23rd. I won't give you a specific time, but we'll fit it into the schedule of other matters we've got set for hearing that day. So that will conclude what we're doing today on the motion to sever. Just to clarify that also, I think the court will just enter an order that sets out those time frames for the responses and replies on that. Next matter we can bring up this morning then, filed by the defense. Mr. Pryor, you filed a motion to compel on January 25th. And this relates also to the ongoing DNA evidence issue that's been brought before the court. The state filed a response on the 27th, and it appears maybe there was some movement on that issue, so the court's uncleared what remains at issue in terms of your motion to compel. Let's discuss that at this time then. Ms. Blake, are you still going to be arguing for the state on the motion to compel?
Yes, Your Honor.
Okay. Mr. Pryor, then, is your motion to compel still at issue today?
Judge, just a portion, and I'm going to be extremely brief. Mr. Wood and I frantically engaged in trying to get the DNA that was eventually, I guess I need to be careful, Judge. A report was presented to me on the 25th. And in addition, there needs to be some additional analysis that needs to be conducted. That was agreed upon at a mutually agreed upon location to have that conducted. It's going to take approximately 3+ weeks to get that to me. So I guess what we can do, Judge, is possibly address that at the next hearing and continue that over to the next hearing to see what the time frame in terms of getting that DNA evidence to me. I do want the court to be aware that I did file a declaration by my DNA expert, and this ties into the next hearing in relation to a number of things. But that DNA expert, acknowledged that once he gets the results in 3 weeks, he'll need approximately 60 days to complete his expert opinion, his report, and his own analysis of everything that's being tested. So that creates a little bit of a problem for us, but I think we'll be addressing that on the 23rd.
Okay. Ms. Blake, what's the state's response then?
Your Honor, we are fine revisiting this on the 23rd. As defense counsel and the court have already acknowledged, the state did provide a response as we'd represented at the last hearing. This was evidence that the state lab was unable to obtain any DNA from. While the state wouldn't necessarily normally pursue additional avenues in order to facilitate a quicker turnaround on this testing being completed, the state did locate a lab that was appropriate and is able to do the type of testing required. That would not be consumptive testing either, but we've been in contact with Mr. Pryor, who had agreed to have the testing completed there. We are hopeful that we may even have the results by the hearing date, and from the representations made, we should have those results back before the next hearing. So I think moving this to the 23rd would be appropriate, and we would probably have a definitive answer for the court on the testing.
Okay.
And Judge, may I reply just ever so briefly, is that once I received the report from the state, if we weren't able to work out an arrangement with the state and come to some sort of a stipulation, it was my intent to go forward with my own independent testing based on what that report said. That would have at least taken 8 weeks plus the time, and I believe I'm already beyond the expert witness disclosure at this point, but that's 2 more months from now. So given whatever the state provides to me on the 23rd or whenever they provide it, the likelihood is there's going to need to be additional testing, and I need to do that. And there are a number of reasons I won't go into, but they go right down to potential appealable issues that may impact whether I, in good faith, exhaust and address all of the issues that may come to me in terms of discovery. So that motion to compel is still floating out there. Getting me a report of the information on the 23rd may address the compel, but there are other outstanding issues.
Well, on that issue then, what I'll do is allow that to be heard again on the 23rd and continue hearing on the motion to compel to the 23rd. Because of the nature of the motion to compel and without the parties being able to control the time frame of when things might be produced, I'll just advise that any additional supplemental filings that relate to that motion be filed before the day of the hearing on the 22nd. If there's any updates on the status of that, or it narrows the scope or needs to expand the scope of the motion, advise the court through a supplemental pleading, Mr. Pryor, and if the state has any response that thinks applies, please do the same also before the hearing, so have those filed by the 22nd. The next motion before the court then is the defendant's motion to extend time for disclosure of witness and expert witness opinion reports and pretrial deadlines. That's a motion filed on January 25th. The state did file a response somewhat concurring with the request, and the response was filed on February 2nd. So given the status of the proceedings, Mr. Pryor, if you'll present argument on that motion to discuss how you want to modify these scheduling deadlines.
And Judge, and the concern is simply this, is that I would, and again, I'm not going to go into specifics, but the concern is that from December 25th to the present time, I count 5 additional supplements of discovery. Some of those were based on motions to compel that I had filed. Some of those involved information that, in my mind, is not only relevant but crucial for my review. I need additional time, and I need obviously additional time from my DNA expert. The deadline to provide the expert opinion, I think, is long past at this point. He's been disclosed. All of my experts have been disclosed to the state. What has not been disclosed at this point are 3 of the expert opinions. They have one of them. They've been provided one of them, and I believe, Counsel, it was a couple of weeks ago that you got that disclosure of my one expert. But I am still waiting on expert opinions from my forensic investigator, my GPS expert, and my DNA expert. And those are the 3 expert opinions. Now, I've also provided the state a list of my witnesses, the lay witnesses that I intend to call, and they have had that for several weeks as well. And I gave the courtesy of providing that to Mr. Mr. Archibald and Mr. Thomas as well. So it's not my lay witnesses. At this point, I seem to be okay. But I do need additional time. And the reason I need additional time, Judge, is this, is that on a motion to compel, I was provided a response from the state, and part of that information they provided me was GPS evidence. But the GPS evidence that they provided me was not entirely responsive, and it needed a follow-up from the state, and quite frankly, the state got back and gave me the additional evidence beyond that. But that GPS evidence was significant in terms of 500,000 bits of information on there, and it has taken a significant amount of time for my expert to evaluate that and to issue a report. And at this point, I don't expect to get that report for probably another week because it was a substantial amount of information. Now, this is information, and I'm not blaming the state. But this is information that has been in the possession of the FBI since before this case even started. And they have had this information, and I have not been provided it. And then suddenly on the eve of trial, less than 60 days plus, on the eve of less than 60 days, I'm given all of this information, and I'm to prepare a report in a case that involves the state potentially seeking the death of my client. I think that's blatantly unfair, and I need additional time. If the court's not going to sever, I can't have a GPS report in time to do that. In terms of the DNA, I think that's self-explanatory. I don't know how I provide an expert opinion on something that I don't have the results from at this point. And the state did provide me what I would describe as a Faro scanner, and that was approximately 12 days ago. And that information is pertinent to my forensic investigator who's looking at that information. Initially, there was a problem in accessing that information. I sent a letter to the state. I think that has been resolved today, and I think I'm going to be okay. But again, I'm going to need to present that to my forensic investigator, have them evaluate it, and they still have to get a report. Now, obviously, I don't expect that to happen for a significant amount of time, but at the very least, I need additional time for those 3 experts, and there's no way, I don't even have the information on 2 of them to adequately prepare that. I don't have the information. And then as recently as Thursday, Judge, Thursday at the meeting that we had in Ada County with all of the parties, and this is, again, not the fault of the prosecuting attorney. It may be the law enforcement problem. It may be a law enforcement problem, but it's not the fault of the prosecutor, to my knowledge. I was handed 1,100 pages of additional documentation that lay out potentially further lay witnesses that I may need to call in regards to this. I will let the court know at the present time that 1,100 pages of documents that I was provided on Thursday, I have not gone through it all, and I have not had the time to go through it all. And even if I worked on it 24/7, Judge, in the next 3 or 4 days, I won't get through it all. Mr. Daybell has not seen it. He's going to get that shortly. But again, this Thursday delivery of this information, and this information, again, has been in the hands of law enforcement for 2.5 years. And I just got handed this information, 1,100 pages. Now, Mr. Thomas and Mr. Archibald are not making an issue of it, and maybe they will. I don't know. But I'm going to make an issue of it, and I'm I should not have to hurry my case up because for whatever reason, law enforcement officials don't find it necessary to coordinate their activities with the prosecuting attorney's office. That's not my problem. That's their problem. And at this point, Judge, I need an extension of all of these because until I get through the 1,100 pages of documentation that they provided me Thursday afternoon, I can't be prepared for this case, and I won't be. And I'm hoping by the 23rd I'll have a ability to review that and decide whether there's additional witnesses that I need to call, whether there's additional investigation. I don't know the contents of all of that stuff, and I just started, and it's going to take me some time. And quite frankly, Judge, extending my deadlines on this, at this point I ought to be working on subpoenas, trial prep, witness prep, expert opinion prep, and preparing for a trial that's supposed to happen in less than 2 months. And instead what I'm doing is still going through discovery that's been in possession of at least a law enforcement agency for 2.5 years, and I suddenly get it. And say, it's okay, Mr. Pryor, it's only death that they're seeking on Mr. Daybell, and only death that they're seeking on Miss Vallow Daybell. But you better hurry up and get ready for this, because we're ready to go to trial. Well, if the court is going to insist on me going to trial, I'll need some additional time.
Response from the state, Ms. Blake.
Thank you, Your Honor. I think we got into some additional argument there, but with regard to a request for an extension of time to comply with the discovery deadline, the state would not have an objection. As we indicated in our written response, we would be recommending maybe a 2-week extension. That would still give the state time to receive the discovery in advance of trial. If the court were to consider something different, we're simply requesting that we receive that discovery in advance of trial in case the state needs to do any follow-up. The only additional concern for the state would be on the chance that something's disclosed that we need to look into and potentially respond, whether rebuttal witness or otherwise, that we also be granted that same opportunity. We're not asking for an extension for the full discovery deadline, just simply if anything produced by defense then required an additional production or disclosure of an unknown witness or something by the state, we would ask for that same courtesy there.
And Judge, in reply, I'm not going to have the DNA evidence in 2 weeks. I'm not going to have the information from the state, and I don't know what else they have planned in terms of what they're going to be providing me at the last minute in this case, and what else is going to be dropped on me in the next 7 to 14 days. So to give me 2 weeks for a report on DNA evidence that I don't even have the information yet is, I think, ridiculous.
And just to clarify, I meant 2 weeks past the current deadline, not 2 weeks from today. Just to clarify and make sure that that was clear, 2 weeks from the 27th was what the state was suggesting, or whatever other appropriate time the court may think, in order to allow defense to comply with that.
Okay, I understand the issues for the court. There is a scheduling order that's been filed. It does have a cutoff for discovery completion by the time of the pretrial conference, which is February 27th, based on the ongoing discovery issues. In fairness to the defense allowing preparation, the court will grant the motion to extend the deadline for discovery, and I will extend that out for 2 additional weeks to March 13th. And if the matter needs to be brought up again because there's still issues and March 13th is inadequate, the court would allow for additional filings, or by stipulation, if the parties reach an agreement on extending or modifying deadlines, the court would consider those as well without hearing. So on that basis, the court grants your motion.
Thank you, Judge.
I apologize. Would the court require us to file a motion so we can get our extension as well, or just Where's the court going to have the order of both cases?
Mr. Thomas, I think you raise a good point because the cases are joined for trial. We haven't scheduled this for hearing today, but I think the parties are all here. Again, we've heard the issue. Would the defense on behalf of your client in the 1624 case be making a same request to extend discovery as it's been extended in the 1623 case?
We would, Your Honor.
All right, I'll let the state weigh in on that request. Calling that as an ad hoc quick hearing here, but covers the same issues. Ms. Blake, any response to that or any objection to the court permitting both parties to have those same discovery deadlines?
Your Honor, I think we're in a little bit of a different posture between the two separate defendants in this case. Mr. Pryor has raised issues, especially regarding expert opinions and expert reports, and he actually provided an affidavit from an expert indicating he was going to need more time, which was why the state was readily willing to agree to that. I think with regard to Ms. Vallow Daybell's case, case number, it's not that we would object. I'm just not sure that we're in the same posture. Now, with regard to any new disclosures that are coming out, based on those, if they're saying we need additional time to look at these and potentially identify witnesses, the state wouldn't have an objection to that. But with any known witnesses, as Mr. Pryor's indicated, he has identified his experts. He has provided reports. I know in Ms. Vallow Daybell's case, we're still waiting on some expert reports for the penalty phase portion. But I think if the materials are readily available and can be produced by the 27th, as much as possible, we'd ask that we stick to that deadline. However, if there are additional reasons in Ms. Vallow Daybell's side of things that the court wants to consider, the state wouldn't necessarily object. I'm just not sure that we're in the same posture with the discovery.
All right. What's your response to that, Mr. Thomas?
The same argument that Mr. Pryor has made, Your Honor. We were also received, and Mr. Pryor indicates that it was 1,100 pages. It was 1,188 pages of just one file, and there are 5 other files involved in that particular discovery disclosure. And so we're running 24/7 on this as well. So I understand where the state's coming from as far as expert witnesses go, and we're prepared to provide those expert witness disclosures in their reports by the discovery deadline. But there are other issues involved other than just the expert disclosures.
And I think with regard to those, the state wouldn't have an objection if they need additional time to respond to that. We just didn't want to blanket push the deadline.
Okay. So on that 1624 case then, based on motion made before the court today without a written pleading, the court will grant a motion to modify the court's scheduling order deadlines from the December 16th scheduling order, which required all discovery to be completed by February 27th. I'll extend that to March 13th in that case for 2 additional weeks. However, the extension on discovery does not apply to the expert witness disclosure requirements. Those will still remain on the February 27th scheduled deadline. The rest of the discovery can be and must be done by March 13th and under the scheduling order.
Thank you, Your Honor.
All right, we will issue a court order indicating how those deadlines were modified so the parties are all clear and there's something in the record in your files to indicate when those deadlines will be set. I believe that concludes the motions you had filed for today. Mr. Pryor, is that correct?
Yes, Your Honor. Thank you.
Okay. At this point,